A gunshot at night, $150, and a body in the ICU. But this isn't a story about a crime, it's a story about the law. It was supposed to be a quiet night. December 24th, 2009. San Antonio, Texas. The kind of cold that doesn't quite feel like Christmas, but cold enough that you stay inside. Ezekiel Gilbert, 28 years old, was home alone. No party. No lights. Just him, a computer, and a plan. The call was made around 10:30 p.m. He'd been browsing a dating website, not one of the big names, more of a back-channel platform known for coded profiles. Not illegal, exactly, but everyone knew what it really was. He messaged a woman named Lenora. She was young, 23, recently moved from Houston. On her profile, a handful of filtered selfies, vague promises of fun, and an hourly rate. Her bio didn't mention escort work directly. It didn't have to. By 11:40, a silver sedan pulled into the cul-de-sac where Gilbert lived. The driver waited in the car. Lenora stepped out, wearing a black jacket and heels, holding her phone in one hand and a small clutch in the other. She entered the house. She never walked out on her own again. The police report later listed her time inside the house at just under 20 minutes. What exactly happened during those minutes, we'll never know for sure. There was no camera, no audio, no witness. Just two people, behind closed doors, and a conversation that ended badly. At some point, Lenora told Gilbert she wasn't going to have sex with him. At some point, Gilbert told her she wasn't leaving without giving his money back. Neither of them changed their minds. So she left. She stepped back out into the cold and walked toward the car. Gilbert followed. What happened next took less than 5 seconds. He went back inside, retrieved his silver pistol, and returned to the front yard. Lenora had already opened the passenger door. She was getting in. He raised the gun, aimed at the car, and pulled the trigger. The bullet hit her in the neck. The driver panicked, drove off. Lenora was slumped in the seat, conscious but fading. Paramedics arrived within minutes and rushed her to the ER. She was still alive, barely. The wounds severed her spinal cord. From that moment on, she couldn't move her limbs or breathe on her own. Doctors performed an emergency tracheotomy. She was placed on life support. Her condition was listed as critical. Meanwhile, Gilbert remained on the scene. He didn't run. He didn't deny it. In fact, according to police notes, he admitted everything right there on his front porch. Said she took his money and tried to leave without doing what she promised. One of the officers asked him why he fired the shot. Gilbert's answer, in the report, was chillingly straightforward. I wanted to stop her from getting away. He was arrested on the spot and charged with aggravated assault with a deadly weapon. At that point, Lenora was still alive. No one knew what would happen next. But here's what struck me most. When I started pulling the case files years later, no one involved, not the arresting officers, not even the district attorney, seemed to grasp how strange this case would become. Because it wasn't just about a man who fired a gun. It wasn't even just about a woman who ended up in an ICU on Christmas Day. It was about what happened after, and how one Texas law quietly started pulling the case away from logic, from justice, and into something far more disturbing. Lenora Frago would survive the holidays. She would survive the spring. But not the summer. And when she finally died, that was when the real legal battle began. By the time paramedics arrived, Lenora Frago had lost consciousness. The 911 call came from a neighbor across the street. They'd heard shouting, then a loud crack that echoed down the cul-de-sac. One woman thought it was a car backfiring. Another knew immediately it was a gunshot. It didn't matter. Within minutes, sirens lit up the street, and the quiet Texas night gave way to flashing red and blue. Gilbert was standing outside when police rolled up. According to the officer's body cam transcript, he was calm, almost indifferent. He didn't try to hide the weapon. It was still in his waistband. When they asked him what happened, he said, "She took my money. I told her not to go. They put him in cuffs, sat him on the curb, and read him his rights." The officer writing the initial report noted that Gilbert seemed more frustrated than panicked, like someone who'd lost a bet, not someone who just shot another human being. Inside the car, Lenora was barely breathing. The bullet had entered the right side of her neck, missing the carotid artery by millimeters but shattering her fifth cervical vertebra. That one injury would determine the rest of her life. The spinal cord damage was irreversible. Doctors told her family she'd likely never move or breathe on her own again. But in those first hours, no one was thinking about the law. They were just trying to keep her alive. She was transferred to University Hospital in critical condition and placed in the ICU. A neurosurgeon performed emergency stabilization surgery that night, but the damage was already done. A ventilator did the breathing. Tubes kept her hydrated. Sedatives kept her unconscious. She would remain that way, mostly unresponsive, for months. Back at the precinct, Gilbert gave a full statement without a lawyer present. He explained that he'd paid Lenora $150 expecting sex, that she had refused and walked out, and that when she tried to get into the car, he felt cheated. Stolen from. I told her not to leave. She didn't listen. I needed my money back. He admitted to retrieving his gun. Claimed he didn't aim at her. Just the car. To scare them, he said. But the bullet had found its mark, a direct hit to the side of her neck. The officers booked him that night for aggravated assault with a deadly weapon, a first-degree felony in Texas, carrying up to 99 years in prison. But there was no murder charge. Not yet. Because Lenora Frago, somehow, was still alive. I spoke with the ER doctor who treated her that night. He didn't want to go on record, but his words stuck with me. Her body was broken. But technically, she was stable. Barely. We didn't expect her to last the week. She lasted longer than that. Much longer. Weeks turned into months. There were minor signs of brain activity, occasional fluttering of the eyelids, a hand twitch. But there was no meaningful recovery. By spring, her condition had plateaued. She remained paralyzed from the neck down, sustained entirely by machines. Her family stayed by her side, took turns holding her hand, waiting. Gilbert, meanwhile, sat in county jail awaiting trial. His bail was denied. The state was preparing a strong case, intent on securing a conviction for attempted murder. Prosecutors felt confident. They had a confession, a motive, a victim. But by the time summer rolled around, it didn't matter what the original charge had been. Because on July 17, 2010, after more than 200 days in the ICU, Lenora Frago died from complications related to the shooting. The medical examiner updated the cause of death, homicide. And just like that, the case changed. Now it wasn't about intent to kill. Now it wasn't about paralysis. Now it was murder. When a shooting leads to a death, the legal path is usually straight dot. A bullet. A body. A motive. A conviction. That's how it was supposed to go in the case of Ezekiel Gilbert. After Lenora Frago died, prosecutors upgraded the charges from assault to murder. First degree. Under Texas law, that meant life in prison, if the jury believed Gilbert had intentionally or knowingly caused her death. And why wouldn't they? He admitted to pulling the trigger dot. He admitted she was unarmed dot. He admitted she was walking away. There was no ambiguity in the facts. The physical evidence matched the story. The bullet's trajectory lined up with the angle of her neck as she turned toward the car. The driver later testified that he heard Gilbert yelling, then saw the flash of the muzzle. He hit the gas the moment the shot rang out. It was all there dot. Motive. Means. Opportunity. But then, things started to shift. During the pretrial hearings, Gilbert's attorney filed a motion that caught the prosecution off guard. A single-page notice, buried in routine paperwork, that mentioned Texas Penal Code Section 9.42, the state statute on the use of deadly force to protect property. At first, it sounded absurd. A property defense in a murder trial? Against an unarmed woman? But the statute was clear. In Texas, a person may use deadly force to recover stolen property, if it happens at night, if there's no other way to retrieve it, and if the property cannot be protected by other means. Gilbert's attorney argued that Lenora hadn't just refused sex. She had taken payment for a service and left without delivering it. That, he claimed, constituted theft. And since it happened at night, and since Gilbert had no other way to recover the money, his use of deadly force was arguably protected under Texas law. It sounded insane dot. It also wasn't technically wrong. The prosecution immediately objected. They argued, forcefully, that you cannot steal money that was paid in advance for an illegal act. Prostitution is a misdemeanor in Texas. Contracts for illegal services are unenforceable. In other words, you can't claim you were robbed when you were trying to buy something that's not legal to begin with. But the judge didn't dismiss the defense outright. That's when I knew something strange was happening. I requested access to the motion docket and reviewed the filings myself. There it was, plain as day. Gilbert was leaning on a law originally meant for stopping burglars and car thieves, and trying to apply it to a fatal shooting over $150 and a refused sexual encounter. And the law? Well, it didn't clearly say he couldn't. Inside the courthouse, something else was happening too. Jury selection. I attended part of voir dire, the legal process of interviewing potential jurors. What struck me wasn't who got chosen, but what kinds of questions were being asked. Do you believe property is worth defending with force? Would your opinion change if the value is small? Do you feel the law should allow citizens to protect themselves and their possessions at night? It was subtle, but deliberate. The defense was setting the table. They weren't trying to deny the facts. They were trying to reframe the story. Not as a murder, not even as a mistake. But as a man trying to stop a thief. And in Texas, that kind of story doesn't fall on deaf ears. Outside the courthouse, there was almost no media coverage. The case had faded from public memory. No protests. No national outrage. Just another trial in a state that sees thousands of them every year. But I knew better. I'd seen what happens when the law doesn't bend, it snaps. In this case, was about to snap in half. Before this case, I had never heard of Section 9.42. Most Texans hadn't. Even some attorneys I spoke with had to look it up. It's buried deep in the Texas Penal Code, under the chapter on justification excluding criminal responsibility. The language is dense, written more like insurance policy fine print than something that can determine life or death. But the more I read it, the more I realized what Gilbert's defense team had seen from the beginning. The law says this. A person is justified in using deadly force to protect land or tangible, movable property, when and to the degree he reasonably believes the deadly force is immediately necessary to prevent another's imminent commission of theft during the nighttime. And he reasonably believes that the land or property cannot be protected or recovered by any other means. It was intended for burglaries, car thieves, ranchers protecting livestock. But here's the problem. The law doesn't define what counts as property in these situations, and it doesn't say anything about how the property was taken. That legal silence created a loophole wide enough to drive a murder defense through. Gilbert's lawyers argued that the $150 he handed Lenora wasn't a gift. It was a payment, an exchange. And when she left without returning the money, it became a theft in his eyes, not a failed date or a business disagreement, but a crime in progress. And because it was late at night, and because he had no practical way to recover the money, Gilbert believed he had the right to act. In Texas, belief matters. If a jury thinks your belief was reasonable, you might walk. So the defense didn't try to justify what happened. They tried to justify how Gilbert saw it. They brought in expert witnesses, a use-of-force consultant, a former police sergeant, who testified that property crimes often escalate quickly and that Texas law empowers citizens to act when they feel helpless. The prosecution pushed back, hard. They reminded the jury that prostitution is illegal in Texas and that money exchanged for illegal acts isn't protected by law. They argued that Gilbert's belief wasn't reasonable, it was delusional, that no one should be allowed to kill someone over an unfulfilled illegal transaction. They said Lenora Frago didn't rob anyone. She refused sex. That's not a crime. But the defense didn't need to win on logic. They just needed to create doubt. And the law helped them do it. The wording of Section 9.42 doesn't require the victim to be armed. It doesn't require the property to have significant value. It doesn't even require that the threat be real, only that the person using force believes there's no other way to recover what's theirs. It's a law written in hypotheticals, in gray zones. And in this courtroom, the gray was starting to take over. I sat in on the trial, watched the jury every day. 12 ordinary Texans, most of them middle-aged. At least 3 former or current gun owners. Several nodded slowly as the defense walked through the statute line by line. I remember thinking, this doesn't feel like a murder trial anymore. It feels like a policy debate, one side arguing for order, the other for rights. And in Texas, there's one right that trumps almost everything else, the right to protect what's yours. The courtroom was quiet. You could hear the hum of the air conditioning, the creak of a chair when someone shifted their weight. It had been a long trial, 5 days of testimony, charts, arguments, reenactments. But now all that remained was the verdict. The jury had been deliberating for nearly 11 hours. I stayed in the hallway most of that time, flipping through my notebook, replaying testimony in my mind. Everyone, even the deputies, assumed it was just a matter of how long it would take, not what the outcome would be. But when the bailiff opened the doors and called everyone back in, I felt it. That strange heaviness in the air. That electricity you only get when something's about to go wrong. Ezekiel Gilbert stood with his hands behind his back, dressed in a navy suit 2 sizes too large. His attorneys looked relaxed. Prosecutors did not. The judge asked the jury foreman if they had reached a decision. He nodded and handed over a single sheet of paper. The judge read silently, then aloud. We, the jury, find the defendant, Ezekiel Gilbert, not guilty of murder. There was a moment, just a second, when it didn't register, like the words had been misheard or mistranslated. Then I saw the look on the prosecutor's face, saw Gilbert's mother raise her hand to her mouth, and I realized this wasn't a hung jury. This wasn't a reduced charge. This was a complete acquittal. Not guilty. Gilbert was free to go. The logic behind the verdict will never be fully known. Jury deliberations are confidential, and the jurors aren't required to explain themselves. But talking to court observers and legal analysts afterward, a pattern began to emerge. It wasn't about whether Gilbert had pulled the trigger. Everyone agreed he had. It was about whether, in that moment, on a dark December night, with a woman walking away from him and $150 in her purse, he reasonably believed he was stopping a theft. And the jury believed that he believed. The law didn't ask if his actions were smart or kind or moral. It asked if they were legally justifiable under Section 9.42. And the jury said yes. One legal expert I spoke with later summed it up this way. If you think a person is stealing your property at night, and you've got no way to get it back, Texas law lets you act. And if the jury thinks your belief was sincere, even if it's stupid, they might let you walk. Prosecutors were stunned. They had never seen that statute used in a homicide case. Certainly not one involving an unarmed woman. They treated the law like a footnote, something to be argued down in closing statements. But the defense treated it like a parachute, and it opened just in time. I stayed in the hallway after court let out. Gilbert left through a side door, avoiding reporters. His lawyers gave a short statement. We're grateful the jury took the time to understand the law. Lenora's family didn't speak. Her father sat alone on a bench, staring at the floor. It's hard to describe the feeling in that hallway. It wasn't outrage, not exactly. It was disbelief. Not just that Gilbert walked free, but that the law had made it possible. And not by loophole or clever trickery. By design. I flew back to San Antonio 6 months later. The neighborhood where it happened hadn't changed much. Same cracked sidewalks. Same chain-link fences. The house where Ezekiel Gilbert lived was still there, just down the street from a faded gas station and an empty lot. He wasn't living there anymore. He quietly moved out after the trial. No interviews. No statements. No apology. I knocked on the neighbor's door across the street, the one who'd made the 911 call. She remembered the night vividly. Remembered seeing Lenora slump in the car. Remembered the paramedics shouting, the lights, the sirens. What stuck with her most, though, wasn't the violence. It was what happened afterward. I kept thinking, if he gets away with this, she told me, what else can people get away with? It's a fair question. Texas isn't alone in having laws that protect property rights with deadly force. Dozens of states have some version of stand your ground or castle doctrine. But Section 9.42 is different. It extends lethal justification beyond self-defense into the realm of possessions. It allows a person to shoot to protect things. Not life. Not family. Things. And in Gilbert's case, that thing was $150, money paid in expectation of a service that was never legally permitted in the first place. That's what I can't shake. Not that a man pulled the trigger. Not that a woman died. But that the law said it was okay. After the trial, lawmakers in Austin quietly reviewed the statute. There was no public debate. No calls for reform. No headlines. Nothing changed. Some legal scholars warned that the verdict set a dangerous precedent, not because it would lead to more shootings, but because it redefined what counts as justifiable belief. If a person believes they've been wronged, and if that belief is framed in the right legal language, it might now be enough to excuse a killing. I reached out to Lenora Frago's family. They declined to speak publicly. Her father eventually sent me a short message. Just one line. She was a person, not a piece of property. I printed it out and taped it to the back of my notebook. I've kept it there ever since. When people ask me why I cover cases like this, I tell them, because they reveal the cracks in the system we trust to protect us. This wasn't a whodunit. It wasn't a mystery. It was a mirror. A man shot a woman in the neck. She lived for 200 days, paralyzed and voiceless, then died. He admitted it. He walked free, not because the system failed, because the system worked exactly as it was written. And maybe that's the most frightening part of all.